Communities making claims on each other's religious places have violently rocked India for decades now. The Places of Worship Act was supposed to put an end to this, but now the law itself is under a cloud. In this episode of Chronology Samjhiye, we unpack why. It was in 1991 that the Places of Worship Act was passed at the peak of the Ram Janmabhoomi movement. To avoid similar disputes, it froze the character of a place of worship as it existed on 15th August 1947. In November 2019, the act was emphasized by the Supreme Court when it allowed the temple at the site of the Babri Masjid. Yet, the floodgates opened soon after. In October 2020, BJP's Ashwini Upadhyay contested the law in the Supreme Court. Within a year, 5 more pleas challenged the law, arguing that it had an arbitrary cut-off date and snatched the right to judicial review. Even as these suits were pending, in May 2022, the Supreme Court itself diluted the law. While hearing an appeal against the survey of the Gyanvapi mosque in Varanasi, Chief Justice DY Chandrachud orally observed that a survey may not necessarily fall foul of the act. 4 months later, a district court relied on this observation to allow a suit by Hindus seeking access to the mosque. This became a Hindutva template. From Mathura to Sambal to Ajmer, over the next 2 years, suits seeking survey of at least 6 mosques and dargahs were admitted. After deadly violence in Sambal over one such survey, the Supreme Court barred trial courts from registering new suits and ordering surveys in existing ones. An observation made by the previous Chief Justice paved the way for a slew of mosque-temple disputes. Under a new Chief Justice, can the Supreme Court make amends?